The affidavit continues with an indication of the matters that took place following that circumstance. And my lords, we wish to underline the fact that in affidavits of the chairperson of the Electoral Commission, she had made clear that we would not be prejudiced by certain decisions of this court because we would have the right to cross-examine. The necessary implication of those statements in a number of affidavits, not just one. The necessary implication of those statements, my lords.
Mr. Speaker, can I just interrupt you? Can you kindly show us the rules under which you are coming?
I'm coming under the inherent jurisdiction of the court, because my lords will appreciate that it is under the inherent jurisdiction of the court that the court grants leave in such circumstances where we have taken a step and we are seeking to reverse the taking of that step. That is in the inherent jurisdiction of the court. And my lords, the circumstances that we refer to of affidavits that were deposed to by the chairperson of the first respondent, those circumstances point clearly to why we could have a reasonable expectation at the time of closing our case that that chairperson would be testifying. We had a completely reasonable expectation of that based on her own affidavits, which are in effect sworn statements. And my lords, these sworn statements actually have very precise legal effect in terms of the evidence laws of this country. In Section 26 of the Evidence Act, it is provided as follows: except as otherwise provided by law, including a rule of equity, when a party has by his own statement, act, or omission intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon such belief, the truth of that thing shall be conclusively presumed against that party or his successors in interest in any proceeding between that party or his successors in interest and such relying person or his successors in interest. Now, my lords, the effect of this conclusive presumption is also provided for in Section 24 of that Evidence Act, where the basic facts that give rise to a conclusive presumption are found or otherwise established in the action. No evidence contrary to the conclusively presumed fact may be considered by the tribunal of fact. My lords, this legal position, as far as the effect of what was in the affidavits of the chairperson of the first respondent is concerned. This legal position was also recognized by this court in the case of Sefa and Asiedu number 2 against the Bank of Ghana number 2. The citation, my lords, is 2013 to 2014, 1 Supreme Court of Ghana Law Reports at page 530. My lords, this was a decision of this court comprising His Lordship and in your board, Justice of the Supreme Court as he then was, and Justices Bafuboni and Badegbe, Justices of the Supreme Court. And their lordships reversed an order of a single justice. And in reversing that order, their lordships made reference to the terms of this Evidence Act. And Justice Badegbe, whose decision was agreed to by the other lordships, had this to say at page 539. By the operation of the effect of the depositions made in the application before the High Court, the applicant, that is, the Respondent Bank of Ghana, is caught by Section 26 of the Evidence Act, which is commonly referred to as estoppel by own statement or conduct, as provided for in NRCD 323 in the words that follows. And he quotes what I have already quoted. And continues, since the said paragraphs 6 and 7 give rise to a conclusive presumption within the scope of Section 24(1) of the Evidence Act 1975, NRCD 323, the court which heard the application for leave to adduce further evidence ought to have come to the conclusion that the facts in respect of which leave was sought for evidence thereon to be led in the appeal had long been available to the applicant Bank of Ghana since the making of the application to set aside default judgment in the matter on 18 July 2012. And then they proceed to quote, Justice Badegbe proceeds to quote Section 24, and then says, further, in our view, as the application to the trial court was prior in making to that made to the Supreme Court for the purpose of obtaining leave to adduce further evidence in the appeal herein, the inconsistency between the two depositions must adversely affect the credit to be placed on the subsequent deposition, and so on. So, my Lord, the point that I'm making respectfully is that in this decision of the Supreme Court, your lordships determined that statements in an affidavit that had been filed in respect of these proceedings established a conclusive presumption which could not justify exercising a discretion to grant leave to adduce evidence. Now, in this case, we're saying by parity of reasoning that we have a situation where the chairperson of the first respondent has in affidavits made clear that the petitioner would in no way be prejudiced because the questions that the petitioner sought to have in interrogatories, those questions could be the subject matter of cross-examination. And my lords, obviously by that time, she had filed a witness statement, and she clearly intended and expressed that intention to testify. And my lords will see that in the statement of case of the first respondent, the statement of case filed by first respondent in opposition to the application for review, and that is one of the attachments to our application, and I believe that it is marked, yes, it is marked recall.
Chikata.
Yes,
Mr. Chikata.
yes, my lady.
Kindly clarify something for me.
Yes, my lady.
You want to reopen your case for the first respondent to testify as your witness?
My lord, not the first respondent. We want to seek to reopen our case. And my lords, as I indicated, we are not seeking leave to serve a subpoena. The serving of a subpoena or the right to serve a subpoena is provided for under Order 38, Rule 10. The person that we intend to serve the respondent, to serve the subpoena on, is the chairperson of the Electoral Commission, the returning officer. That person is not the same as the first respondent, evidently. But that is the person that we intend to serve the subpoena on. It's not on the first respondent.
All right, so she is coming to testify in what capacity?
She's coming to testify on the basis of the subpoena.
But you
She's
said...
coming to testify on the basis of the subpoena because she's a public official. Milady well knows that subpoenas are very often used in the context where, for instance, a public official who may not wish to be identified as testifying, so to speak, as a witness of one party or the other, but who can be subpoenaed so that in their independent capacity they can bring to the court matters which are relevant to the determination that the court is making. Subpoenas are generally set.
I asked this question because of your paragraph 15.
15.
Yes.
1-5.
Yes. He said, as a result of the ruling of the court of Thursday, 11th February, it has become necessary, I'm advised and verily believe that my counsel use the subpoena powers of the court under Order 38 Rule 10 of CI 47 to compel the attendance of the chairperson or first respondent to appear and testify. So you subpoena her to come and testify in what capacity?
As a witness.
Of the first
I'm
petitioner.
not sure
Of the
in what
petitioner.
capacity. She's a witness.
Witness of who? The court or the
No,
petition?
she's our witness, but as the evidence law allows, she is treated as an adverse witness, what in common law was referred to as a hostile witness.
You want to treat her as a hostile witness?
I'm sorry.
Assuming your application is granted, you intend to treat her as a host?
Yes, that is what we're saying, naturally. And my lords, respectfully, at this stage, her status as a hostile witness, adverse witness under the Evidence Act, at this stage, that is not an issue before you.
No.
At
So
this
it's
stage.
totally an issue, you see, because we have to exercise our discretion to grant or refuse your application. And we can only exercise our discretion on extremely appropriate grounds. We need to know what she's coming to do, whose witness is she going to be? And
My lords,
the capacity is important.
she is coming as a witness of the petitioner described in the evidence laws of Ghana as an adverse witness, and in common law described as a hostile witness. That is the capacity in which she is coming.